Hello and welcome back to Law Logical, your weekly dose of the basics of law. Here on Law Logical, we dive into the laws of the land in the most subtle and easy to understand way, helping you navigate the complexities of the legal system, one stage at a time. As part of our ongoing series on the 18 stages of a civil suit under the Civil Procedure Code, 1908, we're breaking down each stage week by week to make sure you know how the process unfolds and what it means for everyone involved. Today, we're moving on to the second stage of a civil suit, the service of summons on the defendant. This stage is absolutely critical because it's where the defendant, or the person being sued, is formally notified of the case. This official notice ensures that both parties are fairly informed, laying the groundwork for a fair trial. To start, what exactly is a summons? In simple terms, a summons is a legal document issued by the court that lets the defendant know a lawsuit has been filed against them. It tells them what the case is about, when to appear, and what to prepare for. Think of it as the formal invitation for the defendant to join the legal proceedings. The rules for the service of summons come straight from the Civil Procedure Code, 1908. Two main sections cover this: Section 27, which requires that summons be served within 30 days of the suit being filed, and Order 5, which contains the detailed guidelines on how service should be carried out. Let's take a closer look. There are different ways to serve a summons, depending on the situation. Personal service is the most common. Here, a court officer, police officer, or authorized person delivers the summons directly to the defendant. This personal approach ensures that the message reaches the right person. For example, if the defendant is at their workplace or home, the officer hands the summons directly to them, requiring their acknowledgement. This makes it official and documented. But what if the defendant isn't available? That's when we use substituted service, covered under Order 5, Rule 20. If the defendant is deliberately evading the summons or is nowhere to be found, the court can order alternative methods like affixing the summons to the defendant's property or publishing it in a newspaper. This way, the court ensures the defendant gets the information. Now, what happens when the defendant is not an individual, but a company, a government body, or a minor? The law has special rules for that too. For companies, summons are served to a director or responsible officer, as per Order 29, Rule 2. For government cases, Section 80 of the CPC requires an advance notice before summons are issued. And for minors or persons with mental incapacity, their guardians receive the summons. The law ensures that every party, regardless of their unique position, is treated fairly and given a chance to respond. Now, let's talk about what happens if the summons isn't served correctly or the defendant doesn't show up. The whole process really depends on both parties being notified. If the defendant doesn't receive proper summons, it can lead to delays and even adjournments. But if the summons was served correctly and the defendant still doesn't appear, the court may proceed with an ex parte decision, meaning a decision in favor of the plaintiff without the defendant's input. Judicial interpretations. Indian courts have seen many cases around the service of summons, refining what counts as a valid service. For instance, in Sunil Poddar versus Union Bank of India, the Supreme Court upheld substituted service, where the summons was published in a newspaper after repeated attempts to locate the defendant failed. This case is a great example of how courts ensure fairness, even when a party is evasive. Practical challenges. There are also some real-world challenges with serving summons. In remote areas, or when defendants try to dodge court notices, officers face a tough time completing service. The law does allow for electronic means of service like email, which is becoming more relevant in modern litigation. This option has been upheld in cases where quick and documented communication is necessary. Summing up. So, to wrap up, the service of summons is one of the most crucial steps in ensuring a fair trial. By formally notifying the defendant, the court upholds transparency and procedural justice. As we saw today, the rules for serving a summons under the Civil Procedure Code are comprehensive, ensuring everyone has a fair opportunity to present their case. If you found this video useful, please like, share, and don't forget to subscribe to Law Logical. Drop us a comment below if you have any questions about the service of summons. We're here weekly to break down the law and help you understand your rights. Until next time, stay informed and stay empowered with Law Logical. Thank you for watching.